Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you take it from there. Obviously, there may or may not be some workings on a set going on, so, whatever. June 20th, Supreme Court opinion, Stanley v. City of Sanford, Florida. Karyn Stanley, a firefighter hired by the city of Sanford, Florida in 1999. She sued the city under Title I of the Americans with Disabilities Act, ADA, claiming discrimination due to a 2003 policy change. Initially, the city provided health insurance until the age of 65 for retirees with 25 years of service or those retiring early due to disability. The 2003 revision limited disability retirees to 24 months of coverage while maintaining coverage until age 65 for those with 25 years of service. Stanley, forced to retire in 2018 due to disability, received only 24 months of health insurance and alleged this constituted disability-based discrimination. To the courts! The district court dismissed her ADA claim, ruling that Stanley was not a qualified individual under 42 U.S.C. section 12112A at the time of the alleged discrimination, as she was retired and neither held nor sought a job, which is what is spelled out in that code. The 11th Circuit affirmed the district court, concluding that section 12112A does not protect retirees who do not hold or desire to hold a job. So the Supreme Court steps in and says the 11th Circuit's judgment is correct. The Supreme Court affirms the decision. The court held that to prevail under Section 12112A, a plaintiff must plead and prove they held or desired a job and could perform its essential functions, with or without reasonable accommodations at the time of the alleged discrimination. The ADA's use of present tense verbs like holds and desires and can perform in section 121118, so just prior to that, and definitions of reasonable accommodation and discrimination indicate that the statute protects current job holders or seekers, not retirees. The court rejected Stanley's arguments that the qualified individual requirement is conditional or irrelevant, noting that the statute protects people, not benefits from discrimination. The court also declined to extend Title I's protection to retirees based on the ADA's purpose, stating that such a change requires congressional action. So separation of powers there, right? So remember, this is not the Supreme Court creating these rules. They're just simply trying to do their best to interpret how the law in question is applied to the situation. Congress creates the rules, and the Supreme Court decides how the rules apply. Okay, back at it. Additionally, the court addressed but did not resolve a potential claim that Stanley was subject to discrimination while still employed, as her complaint lacked sufficient facts. So basically, since Stanley was retired, she was not a qualified individual at the time of the discrimination, which happened because she retired and learned she only got 24 months of health care. All right, Kaimo, keep your mind open, do your own research, form your own opinion. See you on the next one.